Mr. Pryor. Mr. Wood, state's argument.
Thank you, Your Honor. Before I get into the legal argument, just a couple of evidence issues. Mr. Pryor, in his documents that were submitted and admitted, in the metrics folder, there's two documents that we'd like to speak about. And I'm more than willing to do that in a breakout room. It's just data, so I don't know that it's objectionable in any way, but I'll leave that to the court's discretion on how we discuss it.
And Judge, I'm not opposed to Mr. Wood bringing up. I'm fully aware of the metrics and East Idaho News' readership as it relates to Boise and Idaho Falls, and I'm happy for Mr. Wood to go into that. I'll be responding though.
Okay, well, if you'd like to, you can, Mr. Wood. That particular exhibit, I don't believe carries any danger of further prejudice, so I think it's fine to review to those metrics or discuss those metrics here on the live stream, Mr. Wood. So if you have any specifics of that you'd like to discuss, go ahead.
So there's two documents. They're East Idaho News' user data hits on stories. There's two of them. They each have 25 cities. I would note that there is not a single city in Fremont County that shows up in the top 50 cities of hits on East Idaho News stories. The number one city is Salt Lake City. The second city is Boise. But we're not actually here to talk about Boise or Salt Lake or anywhere else other than Fremont County today. And there's not a city in Fremont County that shows up there. I think that's important. So last week,
I guess part of what we have to look at there too is the population base. I mean, last I checked, I think Fremont County's got about 12,000, around 12,000 people. And, you know, when I look at that list, I guess what I'm getting at is number of hits as a percentage of population. So if you've got a certain number of hits in Boise, but there's 500,000 people in Boise, then Fremont County at 12,000 may not show up. And of course, the concern is the amount as a percentage, I guess, of the citizens that may have been exposed. So I'm just pointing that out. I think a factor that must be considered.
And absolutely, I would point out that there's actually in the most recent census, there's more than 13,000 people. And that's not a big difference than 12,000 people, but it is, you know, that's the data. Now, I agree, Your Honor, and quite frankly, some of this data is a little bit murky, but it's still remarkable that in the location of trial, nowhere in Fremont County even shows up in the top 50. And that's all we're submitting that for. As the court noted in the status conference last week, there is a presumption that venue is proper in Fremont County, and that's where the trial should be held. And it's the defense's burden to overcome that presumption. There's two types of prejudice when you're talking about a fair jury in terms of venue. There's actual, which we can't talk about because you have to actually try to pick a jury to get there, or presumed. And at a minimum, the defendant's burden is that he has to show a reasonable likelihood that prejudicial news coverage prevents a fair trial. And in State versus Haddon, it's an Idaho case. The court there recognized that most cases of consequence garner at least some pretrial publicity. However, a presumption of prejudice requiring a change of venue attends only the extreme case. And there's a test for that. And that test remains whether the trial atmosphere has been utterly corrupted by press coverage. Further, State versus Yeager, it is not incumbent upon the trial judge to find jurors who are totally ignorant of the facts and issues involved in this case. Further, in Yeager, publicity by itself does not require a change of venue. An error cannot be predicated on the mere existence of pretrial publicity concerning a criminal case. Now, Mr. Pryor did predict my argument. Yes, the state concedes there's been a lot of pretrial publicity. The state would note that the state has made several attempts to lessen that. We asked that cameras not be allowed in the preliminary hearing, not to seal the hearing, and that's in another case, but it does bear on the publicity of this case. We asked that that not be allowed, to simply lessen the amount. And we noted that there's no right to a camera in a courtroom. The Supreme Court's been explicit about that. Mr. Pryor and Mr. Daybell asked that it be shown publicly. So the biggest source of evidence involving this case, Mr. Pryor and Mr. Daybell asked that it be broadcasted to whoever may want to see it, whether that's in Fremont County or outside of the county. So the court has been very clear. There's factors that this court must consider in determining whether or not the defendant has met its burden. The first, the existence of affidavits or indicia of prejudice in the community. Mr. Pryor has not provided one witness to state that they've been prejudiced. He's not provided one affidavit. The case law is replete and talks constantly about providing affidavits to show prejudice. Not one affidavit has been provided. Not one indicia of prejudice has been provided. Not a single witness. The accuracy of the pretrial publicity. Mr. Pryor has not made any attempts whatsoever to show any evidence that the pretrial publicity was inaccurate. He hasn't put on any witnesses to talk about it. He hasn't indicated it himself. There's no showing has been made. The extent to which the articles are inflammatory, inaccurate, or beyond the scope of admissible evidence. Again, the defendant is on the burden to show that the general public has been exposed to inflammatory publicity, inaccurate publicity, or publicity based on non-admissible evidence. No such showing has been made. I'll just briefly reference the Heather Daybell email, and I'm not going to get into the facts of it. He can't show how many people received it. He can't show how many people read it. He hasn't produced a single affidavit from anyone saying they were prejudiced by it, nor has he produced a single affidavit of any individual saying they're prejudiced by any of the news. The one area where the number of articles, the state does concede there has been an extreme amount of news surrounding this story. However, the court is clear. That alone does not create a presumption of prejudice.
Mr. Wood, though, on the factors the court does consider, I think, though, the amount in and of itself is certainly a factor, I think, that gets considered. I would note there's a case, State versus Hall, which is an Idaho case, 111-827. And that says impartiality may be affected adversely by the quality or the quantity of pretrial media coverage, and goes on to state that when prospective jurors are incessantly exposed to news stories selectively packaged for mass consumption, they may become subtly conditioned to accept a certain version of facts at trial. Such repetitive exposure may diminish the juror's ability to separate information absorbed before trial from information presented during trial. And that cites to another case, State versus Brooks, 103, Idaho, 892. So while there's an argument maybe that the publicity has been accurate, I think just at some point in overwhelming quantity may be something that could lead to that issue discussed in Hall. So I haven't reviewed through all of the exhibits yet to see where we are on that, but I want to let you know that's a concern I do have, is just strictly based on quantity of coverage based on that case.
Well, and it's absolutely within the court's discretion to do so. That, like I said, that is one of the factors, is the number of articles. I would just point out, though, that the case law is clear that press coverage itself does not create a presumption of prejudice, but the court is absolutely correct in its discretion to review the number of articles and the substance of them. And that dovetails with whether the potential jurors were so incessantly exposed to such articles that they had subtly become conditioned to accept a particular version of the facts at trial. And I think there's been no showing today, and obviously the court has those items in evidence. It can review those items, and it can make for itself a determination whether or not it's inflammatory, whether or not it's accusatory. I don't know that I've seen a single East Idaho news story that said anyone was guilty or anyone's not entitled to a fair trial. that would be inflammatory. Anyway, I think the court is entitled to absolutely look at that and make that determination. But the facts that have been related are that the state has seen, and I'll let the court make its own determination, but appear to be true. They're not fortunate facts. They're not good facts. They're not fun. They're disturbing, but accurate representation in the media, absent of showing the prejudice, it should not be enough. And then finally, the length of time elapsed between the pretrial publicity and the trial, and any assurances given by potential jurors themselves concerning their impartiality. This is a little more difficult to look at because we don't have a trial date set. We don't know when trial is going to be, nor do we know what news is going to come in between now and the trial. We don't know if another case is going to come along and blow this one out of the water. We don't know if this case will become the biggest case in the country. So that's difficult for a court to make a determination on that. Again, Your Honor, there is a burden of proof. The defendant is responsible to show a reasonable likelihood that prejudicial news coverage prevents a fair trial. And for that presumption of prejudice, he has to show that this is an extreme case, whether the trial atmosphere has been utterly corrupted by press coverage. I think to get to that point, Your Honor, he has to show some actual prejudice. He has to show, he has to have some witnesses. He has to have some affidavits of people who show prejudice. And he can smile and shake his head no, but that is the burden set out by the case law. And the state will, again, the one thing I do want to point out, there's a lot of talk about the press coverage. There's been nothing that links it just simply to only in Fremont County. It's all over the state. And so I think that's important for the court to consider as well. The hearing today is about Fremont County. And as far as Fremont County is concerned, I don't believe that burden has been met.
All right, thanks for the argument, Mr. Wood. Mr. Pryor, I'll allow you a rebuttal argument if you'd like. Before I do want to address that fact of what's the direct evidence I have about any prejudice within Fremont County itself that's been presented today or that's in the record. And the other issue is, well, not just on that, but why, what would be I know there are some downsides, but why would it not be appropriate to potentially go see if we can get a jury picked? And if that, through the process of voir dire, obviously we can vet out jurors and see where we land. And then if we determine through, instead of the court having to make a determination here based on this, seeing what actually happens when we get enough jurors there to call, why wouldn't we make a try there first before we go through all of what's going to take to move the trial? So those are the two issues I'm thinking about in this decision, if you want to address those.
And Judge, I'll address your first decision about trying to get a jury in Fremont County and then seeing if we're able to do that. The concern, Judge, is in many cases, that's not an unreasonable request. But this isn't any case. This is probably the biggest case in our country right now. And the case involves 6 counts that could cause Mr. Daybell to be given a lethal injection. And what the court is suggesting is that we're going to pick a jury. And oh, by the way, if we're not able to pick a jury out of Fremont County, at that point, then maybe we need to look somewhere else. But the picking of a jury is not just as simple as bringing 100 people in and saying, let's pick 100 people and see if we can find some people to do this. There are going to be, and then obviously the court's going to see these motions, but there are going to be studies. There's going to be questionnaires. There's going to be a lot of effort. And in my past, when I've been involved in significant cases, there have been times when picking a jury has taken a week, has taken 2 weeks. And if the court is going to invest a week or 2 weeks in picking a jury, and then we come to the conclusion that we're not able to pick a jury here, at that point, we then have to find a place to find a jury to pick and go through the 2-week process again. It would seem that's a waste of resources. Mr. Wood seems so concerned about resources that he forgets that this is Mr. Daybell's right to a fair, impartial jury. And even though he's waived a speedy trial, Judge, Mr. Daybell's been locked up for a significant amount of time. if for some reason in several months from now, we're not able to come up with a jury, it's going to be several more months, maybe even longer, before we can get into another jurisdiction where we're going to pick a jury. So the reality of it is this, is that taking a test run and taking a stab to see if we can do it. When you're dealing with a death penalty case, that's not the manner in which you proceed. The manner in which you proceed is you find an appropriate jurisdiction that you know you have the best chance to obtain a fair and impartial jury. And from my position, the largest metropolitan area in the state of Idaho is Boise, the Treasure Valley. Whether that's Ada County, whether that's Canyon County, that's where we are more than likely to find the largest number of people who may not have heard about this or have may not made up their decision. Now, the prejudice and the direct prejudice question, Judge. This court made it very clear, and I had advised the court that I had a slideshow that I was intending to show a number of slides, and I was intending on putting on a significant presentation. This court was not going to allow me to present certain slides and certain evidence. In fact, the court stopped me on the Heather Daybell thing and said, I'm not letting you get into this. Now, isn't that the very definition of inflammatory or influencing?
And to be clear, I'll review that evidence. The evidence is there and you can refer to it and I can look at it for what it is and make that determination. So it was only in expressly relating to it an argument that I curtailed there, Mr. Pryor.
Right. And Judge, if it wasn't so inflammatory, if it wasn't so concerning, we'd be showing it to all the people watching right now. But the reality is there is disconcerting stuff. And Mr. Wood can put in his pleadings, and Mr. Wood, and this is all on the stuff that I submitted, Mr. Wood can do a press conference and announce that he's seeking the death penalty, and Ms. Blake can get on there and speak.
No, Jack, that's a fact, not an evidence, and that never happened.
Well, that's the objection sustained because that's outside of the scope of anything presented at the hearing here, Mr. Pryor.
Well, it's in the evidence, Judge, and it's in the videotapes that have been submitted. So
okay, it's there, then I'll consider it. And
at that point, Judge, you know what? Mr. Pryor hasn't gone on public TV. Mr. Pryor hasn't gone on court TV. Mr. Pryor hasn't gone on Dateline or anything else and done anything like that. But what has happened in Fremont County is Heather Daybell wrote a letter to the Henry's Fork Stake. That letter was disseminated, and the court can read the article about how far it was disseminated. That's a problem for us. That's a problem for a fair trial. And then what did we hear about today? The sheriff of Fremont County in 2020 on his personal Facebook account posted images of the Daybell case. Now, Mr. Wood brought up, well, you didn't mention Chad or Lori. No, he just mentioned Tylee and JJ on it, and then talked about some other things that were posted as part of this. If you're telling me that a sheriff in a county whose job is part to investigate this case and to provide assistance to Mr. Wood gets on his personal Facebook account and advertises out there, you're telling me that that's not going to have an impact? You're telling me that's not going to influence citizens in rural Fremont County? That is absolutely ridiculous to suggest that it wouldn't influence people. Finally, Judge, again, I keep going back to this. Mr. Wood is misconstruing the case law as it relates to venue. Mr. Wood is absolutely misconstruing the case law and what it says. If the media coverage is so great that it inherently is going to influence the outcome or attention brought to this case, that's in case law, that's addressed in the Hall case that the court brought up, but more importantly, Judge, it's addressed in our highest court in the United States, the U.S. Supreme Court. And they have clearly set forth the standards, not the standards Mr. Wood would like you to follow, but the standards that all of us should be following. Judge, I've been doing this for a little north of 25 years. I have never seen a case that has brought on so much attention. I have never seen a case, and the court can go back, and I can't even imagine the task this court has of having to go through all of the evidence that I've submitted. Many, many items of evidence that this court's going to have to sift through, and it's a huge task. It's a monstrous task. It was a monstrous task to go through all of the stuff for me. I can't even imagine. But Judge, if it's that big of a task, that would suggest that the media attention has been significant, more than significant. It's been outrageous. And it's not a coincidence that in Idaho Falls, Idaho, now I don't want to misstate how far St. Anthony is from Idaho Falls, but these folks in this side of the state have their very own news agency, East Idaho News. This is a very prominent news organization. And whether I agree or disagree with everything that they put on there, and obviously I'm not going to make a public statement, but I don't agree with what's been said about Mr. Daybell. In fact, most of it I disagree with. Almost all of it I disagree with. And unfortunately, now I've broadcast that. But that's not the meter that you go by. You apply the Irvin versus Dowd in the cases I applied. And there is no way that with the amount of tension that Mr. Daybell could get a fair trial here. And the difficulty is, it's not let's like shoot basketball hoops and hope maybe we could sink a few and get a fair jury. We don't get to take a try and say, well, let's take a stab at it. And if it doesn't work, well, we'll move it somewhere else and take another stab. That just doesn't make sense. So I would encourage the court to please, this needs to be in the western part of the state, in Boise, Idaho, in Ada County, and that would be the best chance we could get for having a fair and impartial jury.
Okay, thanks for the argument, counsel.
Your Honor, I don't want to re-argue anything.
I was going to say,
I'm
Mr. Wood, if you have
objecting.
any additional argument, you may.
All I wanted to say, Your Honor, the state just really, the way that Mr. Pryor has discussed Sheriff Humphreys, we strongly disagree with. He hasn't cited any law, any rules of ethics, or anything else that he's done wrong. And the way that he treated him as a witness and the way he spoke, we just strongly disagree with, and we'll leave it at that.